departmental agenda item number 3 from probation.
Madam Chair, members of the board, item 3 is from the Probation Department. It's a hearing to receive and file the Public Safety Realignment Operational Impacts Report for July through September 2012.
Okay, Chief Taylor, good morning.
Good morning. Good morning, Chair Farr and Supervisors. I'm Beverly Taylor, Chief Probation Officer, and with me today is Chief Deputy Sheriff Don Patterson, and we'll be here today to provide our first quarter update for Public Safety Realignment. Also here is Damon Fletcher, and would be available for any financial questions that you might have. Public Safety Realignment, as you're aware, was implemented in October 2011 as a solution to the state's prison overcrowding and as a relief to the state's fiscal concerns. Realignment directed the responsibility for offenders with convictions for certain lower-level felony offenses from the state to local jurisdictions. Counties received formula-based funding to manage this new local responsibility. Each county was charged with developing a local plan for implementing public safety realignment. Santa Barbara County based its plan on the notion that success would require a multi-pronged approach. The approved plan balances funding across incarceration alternatives to detention, case management and supervision efforts, as well as evidence-based treatment and services. Today we will highlight population trends over the past 12 months, which include the number of realigned offenders under probation supervision, what impacts these offenders have had on the court and jail operations. Chief Patterson will provide a staffing update and an update on the overall impacts AB 109 has had on jail operations over the past 12 months. A financial update of the first quarter will be presented, and closing remarks from Sheriff Brown. Realignment transferred 2 state populations to local jurisdictions. The post-release community supervision parolee, or PRCS, who are now under the supervision of probation, and the offender serving time in local custody rather than in state prison, the nonviolent, non-serious, non-sex offenders, or the NX3s. The NX3 offender can be sentenced to straight jail or to jail with a period of mandatory probation supervision. As of October 1st, there were 364 offenders under supervision.
Excuse me, Chief Taylor, I'm sorry to interrupt you. Mr. Allen, I don't, and at least Supervisor Carbajal doesn't have a copy of this presentation. Did we get any hard copies?
Yes, those would have been distributed. I can go get copies, though, and bring those in right now.
Yeah. And I'm looking online, and is it online? It is? Do you have it, Steve? No? Okay.
Yeah, why don't we just take a break for just a couple of minutes until we can get the rest of the materials. All right, we'll go ahead and reconvene here. And Chief Taylor, I'm sorry if you'll go ahead and continue your presentation.
Thank you, Chair Farr. As of October 1st, there were 364 post-release community supervision offenders under supervision, and this number is consistent with projections included in our fiscal year 12-13 realignment plan. Through the first 12 months, there were 7 mandatory discharges for PRCS offenders who did not have a violation that resulted in custody time for 12 consecutive months. It's too early to know how this particular outcome is going to relate to the states, but we should know that in the next 3 months or so. Flash incarceration is a tool under realignment that provides a swift consequence for a minor technical violation. Probation officers are authorized to incarcerate a PRCS offender for up to 10 days without a formal court hearing. During the first 12 months, there were 221 such bookings. In the same time period, there were 21 revocations, which resulted in a recommendation of over 10 days in jail. And of that number, 15 waived a formal court hearing, leaving 6 who impacted the court with a formal court hearing. Post-sentence supervision offenders are ordered to serve a split sentence, including a portion of their time in jail and a mandatory period of probation supervision. This number is also consistent with projections, and as of October 1, we were at 62. Since implementation, there have been 219 NX3 offenders who have been sentenced to local custody time, which is consistent with projections. This includes the 62 offenders who received a split sentence. Locally, offenders with a split sentence accounts for 28% of all of the NX3s. The state's average after 6 months was 24%. Local partner agencies, including the court, are all in favor of split sentences. A concerted effort to better inform attorneys of this benefit and to conduct an analysis of the types of cases receiving straight sentences will help us to pinpoint how to more effectively use this sentencing option.
Actually, just a moment. Supervisor Wolf.
Thank you. Ms. Taylor, I was interested in this because you mentioned it in the body of your staff report about kind of alluding to some concern about the number of straight sentences. So in your comments just now, you mentioned that you're going to be working with the parties to not necessarily remedy this, but maybe alter the statistics so it's more in line with what we might expect. What exactly do you mean by that?
What we need to look at, I think it's going to be a two-prong approach. One, we need to look at the types of cases that are being sentenced to a straight sentence only. In our first 6 months of data collection, we noted that on average, the remaining time for all of our split sentences was approximately 240 days. So there were some split sentences that maybe they had served all of their time and were released at the time of sentencing. So I believe, again, it's two-pronged. One, we do need to provide information to the attorneys as to what services these offenders would have in the community, the benefit for a split sentence, but also take a look at our numbers and what is a true percentage that we should be trying to attain. There are some counties that have as high as 80% split sentences, and some, have none. So to better gauge what Santa Barbara County's threshold or standard should be, we really do need to look at what those cases that are being ordered to a split sentence, what are they, and analyze them to see how many of them potentially could have been a split, and how many were more appropriately sentenced to a straight jail only. So we need to do a little more work on our end. Thank you.
Go ahead.
Okay, I'd like to turn it now over to Chief Patterson.
Good morning, Madam Chair, members of the board. With me today is Lieutenant Charles Powell, who's in charge of our alternative sentencing that includes the GPS and early release programs. I will be discussing three main areas today. staffing updates, incarceration trends, and AB 109 bed days. Over the last year, we have made a concerted effort to hire custody deputies. We are seeing the culmination of over a year of intense recruitment and hiring so far. So far in this calendar year, 2012, we have hired 27 custody deputies. To help put this intense hiring effort into perspective, during the calendar years of 2008, 9, and 10, we hired a total of 23 custody deputies. So we've hired more this year than we did in the last 3 years combined. We currently have 9 custody deputy vacancies, and we have 12 custody deputy applications being actively worked and plan to open recruitment for a new custody deputy test within the next few weeks. In an effort to address the shortage of custody deputies in the jail, the Sheriff's Office transferred 12 deputy sheriffs from law enforcement operations to the jail in August of 2012. These sheriff deputies will augment the staffing shortages until enough custody deputies can be hired to replace them, and they will then be returned to law enforcement operations. Our compliance teams have been selected and the vehicles have been outfitted, and we will be online with our compliance teams and operational on December 10th of 2012 this year. Our social workers and community program coordinators, we're still looking to hire them. We have exhausted the list. We're not able to hire anyone off the current list, and so we're looking at having a new list for that. Under our incarceration trends, in the first year of AB 109, we housed 954 AB 109 inmates in the jail. This housing ranges from as little as 10 days for flash incarceration to the longest sentence of 23 years. A single-day snapshot on August 1st of this year showed that we had 155 AB 109 inmates in jail in custody. We had an additional 22 AB 109 inmates on GPS. The requirement to absorb the 155 inmates into our system that was already overcrowded re-emphasizes the need for the North County jail construction that was approved by this board last month. The new North County jail will ease the inherent liability that comes with overcrowding and provide an environment that is more conducive to longer sentences created by AB 109. The average daily population of our jail continues to rise over previous years. When comparing the months of October 2011 to October 2012, we had an increase of 168 inmates, or 19%, in our average daily jail population. By these numbers alone, you can see the increase of 19% is mostly a result of the AB 109 155 that we had in jail in October. We have seen a 22% increase in our GPS population year to date, and our Sheriff's Work Alternative program, which is our SWAT program, is actually down 30%. This program is our community service program. We believe this program has been lowered because of the lack of ability to put people in certain locations because they have to give them workers' compensation, and also we're really screening people out more for medical reasons now to avoid a liability with the department and the county. Our cap release or early releases per the court order on overcrowding are starting to slow down from those we experienced in the first 6 months of the year. I attribute this reduction to the fact that we are starting to experience the impact of the longer sentences of AB 109, and there are simply less inmates coming to the end of their sentences who are eligible for early release. Currently, year to date, we have seen an increase of 7% in early releases over 2011. And you may recall last time I mentioned that actually 2011 was a record year low, and we're still well below those of 2008, 9, and 10. At the central core of realignment is the effort for the use of evidence-based practices to address decisions on incarceration programs and services that ultimately reduce recidivism. We have reported before that we use 3 main instruments in determining eligibility for alternative sentencing. These instruments are the initial screening tool, or the IST, the COMPASS tool, and the Static 99. The IST and COMPASS tools are used for everyone except sex offenders. The Static 99 is used for sex offenders since it was specifically developed for those purposes. These instruments provide a variety of information regarding the risk for recidivism and violence and certain criminogenic needs that can be taken into account to determine proper programs and services offered to those who are released. With the assistance of probation officers funded by AB 109, we have fully implemented a plan to screen everyone in the jail to determine their eligibility for alternatives to incarceration. While our current emphasis is on post-sentenced inmates, we also consistently scan for pre-sentenced inmates who qualify for GPS monitoring. You may also notice that in a report that so far we have not released anyone in GPS in lieu of bail. The requirements for consideration for release on GPS in lieu of bail are that inmates are held in jail with no other reason other than the inability to bail themselves out. They can have no other warrants or holds placed upon them. Misdemeanors must have been in jail for 30 days and felonies in jail for 60 days to be eligible for consideration. The simple reason that we have not released anyone in lieu of bail is because the courts are doing a very good job of releasing individuals on their own recognizance and setting bail where most can afford to bail themselves out of jail. We also sight release most misdemeanors on a promise to appear in court. Those who are left in jail have egregious crimes, extensive criminal histories, or a history of noncompliance that pose a threat to public safety if released, and so we have not released any of them to this date. The number of those on GPS monitoring has held steady for the last few months. Similar to the early releases, it appears we're hitting a wall with respect to the number of individuals who fit into our selection criteria. The annual AB 109 conference in Sacramento last week, there is a lot of discussion about using a combination of instruments to provide secondary filters to assist us in refined decisions concerning releasing individuals on GPS and other alternatives to incarceration. We will continue to coordinate and collaborate with probation and investigate how we might use some of these secondary instruments in conjunction with the ones we are using now to assist us in our decisions and programming. We've also seen a decrease, as I mentioned, in the number of people enrolled in our SWAT program. Concerning bed days, for this quarter, the number of reported AB 109 jail bed days has been modified to remove offenders being held on new criminal charges and technical violations. While the percent of bed days is lower overall than in previous reports, the last 3 months have showed a continuation of the leveling trend we experienced last quarter. I expect this leveling trend to continue steady as we head into the next years into full rollout. We are on schedule to complete a programming revision in January to our computer system that will allow us to further refine our calculations and determine them electronically rather than our present method, which is all done manually. Once the computer reprogramming is complete, we can go back and update last year's data based with these new refined calculations methods. In the annual AB 109 conference held last week in Sacramento, Dr. Joan Perticilia, one of the foremost experts in crime and sentencing in the United States, stated that the first year of AB 109 was mostly planning, organizing, and collecting data. The second year is for polishing collection methods and analyzing data, and that will be where our efforts are put next year. I will now turn the information and the presentation back to Chief Taylor, who will present the financial status of the program.
Thank you, Chief Patterson. Supervisor Gray has a question, and then I have some questions as well.
Actually, I have a statement that I'd like to make. I am now serving on what is known as the Correctional Facilities Executive Committee in Sacramento, and we have $500 million that we are tasked with handing out for correctional facilities in local areas. And I'm one of 2 supervisors that's on this committee. There's one from Contra Costa than myself. There's 4 sheriffs, 2 probation officers, and 1 mental health representative. And the reason I'm bringing this up, because I just want you, all of my colleagues, and everyone in the room to know that Santa Barbara County is just head and shoulders above what other counties are doing with these programs. And specific example was Santa Cruz County probation officer is on this commission. And he kept talking about, well, we've just got to do a whole lot of things before we do anything else. And finally I said, well, what is it that you're specifically referring to? And he was talking about OR release. I mean, my Lord, we've been doing OR release in this county since 1987 that I know of. So all of these things that our folks are telling us about are truly cutting edge of what's going on in every other county. I just was amazed to know that. So as we listen and try and solve the 108, the commission that I'm on is AB 1009, handing out that kind of money. But it is just a great feeling, and it was a hello to me, because we just hear them all the time, and so we don't really know how far out they are. So thank you, congratulations to this board, the CEO, everybody, the sheriff, everybody involved. It's not like we're behind the 8 ball here, we're right ahead. So congratulations. That's what I had to say.
Okay, great, thank you. Supervisor Wolf, it's always good to know that, when you're at the statewide level, how well we compare, which is not a surprise for us, but still nice to hear. Supervisor Wolf?
Thank you, Madam Chair, and I would second what Supervisor Gray said. When we were in Sacramento, just as these plans were being developed. I do, and I think I may have mentioned it at one of our board meetings, someone from another county just literally wanted to take the plan out of my hands so that they could use it. So yes, we are one of the model counties, and I think that this collaboration of all of you has been terrific. I'm glad, Mr. Patterson, that you touched on the reason why we're not seeing any releases, the way it's written here. We're not seeing any releases to home detention in lieu of bail. So what I think I heard you say is that these folks are at a level that they should not be considered for bail. The courts have already allowed folks to be on their own recognizance or reduce their bail, and for whatever reason, when you have evaluated them, they are not eligible. And I just want to confirm that, because I have looked back over the last 3 months, and the same pattern exists, where there have been no releases in lieu of bail. So will that ever change, or do you expect that this is going to be a static statistic?
Supervisor Wolf, through the chair, I believe it's probably going to be a static statistics. There are some potential cases that we review individually that may come up. I actually have a sample of a couple of the ones that are held in lieu of bail, and of course I won't say their names, but I can talk about their charges and their bail, just to give you an example of the ones we're holding in lieu of bail. This was actually done a few months ago. But the first one is $1 million bail. It's mostly drug-related charges, vehicular manslaughter, speed on the highway, possession of less designated controlled substance, and drug-related charges. So that's one of them. The other one is $100,000 bail on possession of burglary tools, illegal possession of a firearm, participation in a criminal street gang. I have another one that's $400,000 that's receiving stolen property, attempt to commit a crime, burglary, driving on a suspended license, and destroying evidence and possession of controlled substances. There's several of them in here that are sexual assault cases that, those go for themselves in terms of public safety. And I can go on, but those are the types of crimes that we're looking at now that are eligible for consideration in lieu of bail, but we've decided not to let them out.
I appreciate that, but wouldn't sexual assault, I thought that they're not considered to be part of this population. They're not a NX3, as I understood it, that they wouldn't even be considered for this program.
They may not be considered part of NX3s, but we do have some misdemeanor sentencing. We do have some on misdemeanors that are being tried for misdemeanors that are eligible under the criteria, because again, the criteria is if you're in for a felony for more than 60 days and only have a bail amount with no other charges and holds, you fall under consideration for being released in lieu of bail. And so because they're not sentenced, they don't fall into the NX3 part. That's only the sentenced people. It's the unsentenced ones where they may, after sentencing, fall into that category, but this is pre-sentence.
Okay, but I just think it's important for me to understand that this population, the NX3s, are not those high-level criminals that we would never consider anything in lieu of bail as part of this program. Give me an example of one that you would consider. You mentioned $400,000 bail or $1 million bail. And because I'm not familiar with the legal justice system, would someone, for instance, be in jail and be held on $10,000 bail and it be an NX3, it be a misdemeanor or not? Basically, what I think you're saying is that no one who comes into jail and has a bail will not be released under this program or under supervision.
The NX3s are only considered NX3s post-sentence in terms of whether they're actually sentenced to the jail or not. They may be tried, but in terms of after they're sentenced, then they are placed in the jail in terms of serving their sentence. This is all pre-sentence, so they're still in trial. They haven't been tried and convicted of anything yet. So some of these may go to trial and may end up being sentenced as NX3s. Other ones may be sentenced as non-NX3s. So we're talking about both. Sometimes you actually may be tried on a felony, but found guilty of a lesser included crime, which is a misdemeanor. So they might have been tried as an NX3, but sentenced as a misdemeanor. So this includes all of them. And to give you an example of one of the ones that we may consider, we're talking about maybe drunk driving. Maybe someone's in jail for drunk driving. They've had 2 or 3 priors of drunk driving. They're in jail on $25,000 to $50,000 bail. They've been sitting there for 30 or 60 days. They're eligible under this criteria to be considered for release on GPS monitoring. That would be someone which we would consider. We'd probably put them on a scram, which is an alcohol device also, and do a combination of both if we actually let them out. But those are some of the ones we would consider releasing. We don't have any of ththose that's come across my desk at this point.
Okay. Thank Ms. Taylor, did you want to say something?
Chair Farr, Supervisor Wolf, yes, just so the in lieu of is for any offender in custody who meet certain criteria. It's not only for the AB 109, the PRCSs, or the NX3s, but it's anyone in custody, misdemeanor or felony, who meet specific guidelines. And as Chief Patterson indicated, for misdemeanors, they have to be in custody for at least 30 days to be considered on a pretrial release in lieu of, and for a felon, they have to be in custody for at least 60 days. So it's the total population of the jail that can be considered for the in lieu of.
So maybe then for these reports, I'm just not clear why we would have that as part of our information then. If it's not related, if these folks are not 109ers, why would they be included in our report? Other than I do think it's interesting information. But
right. And it came about as part of realignment. So it was a tool that was given to local county, the sheriff, so that gave them an opportunity or a vehicle to release other types of offenders to make room potentially for the AB 109. So it's a tool. We can certainly take it off. Okay.
Chief Patterson, I wanted to go back and ask you about the staffing, because I know that having the vacancies for the custody deputies is having an impact on overall operations, because you said that you have had to pull 12 other deputies in to kind of fill in. So you said you had 9 vacancies that you're trying to fill right now. Now, are those existing vacancies, or were they additional vacancies created by AB 109? I mean, additional need for custody deputies.
There are existing vacancies. AB 109 funds, I believe, about 15 custody deputies throughout the custody operations, and we don't necessarily separate those out. These are actual vacancies on the actual main floor of the jail. So to answer your question, yes, there are 9 hard vacancies we have right now that we're trying to fill. Some of them may be funded by AB 109 depending on where we actually eventually put them, but we don't really separate those out, and we draw down the AB 109 funds based on where people actually are assigned. So when they get hired and signed off, they may be put in those positions, but we haven't made that decision yet.
Okay. Well, what I'm trying to do is get a good understanding of what the overall custody deputy need is. So I'm assuming that the 9 vacancies that you're trying to fill now are kind of the bare minimum, and then there are going to be others that will probably need to be filled after that. Is that correct?
Madam Chair, that is correct. We have 9 vacancies that we're trying to fill now. I believe we're having 3 more come online after the first of the year that was authorized by the board last year. We're also looking at a fair amount of custody deputies moving over into the deputy sheriff world, so that'll create some more vacancies for us in the next couple of months. So all that's going to equate to probably another 14 to 15 vacancies by the first of the year.
Okay. And so I know it's probably impossible to guess, but if you had to, how long do you think it's going to take before you'll be able to fill all of these so that the people that you've had to transfer from the other operations can be transferred back to what they were doing before?
Madam Chair, we're planning on starting that transfer probably after the first of the year. We really want to wait till maybe February, March till we see how many people actually retire and what the actual vacancies are, but we will start transitioning them, the deputy sheriffs, back to the street after the first of the year. We currently have 17 custody deputies on training right now, and as those deputies get off of training, that'll allow us to assign them to posts that deputy sheriffs are currently filling. So it'll be a transition process over the next 2 to 3 to 4 months.
Okay. So hopefully, maybe by the end of this fiscal year, some of this will have kind of balanced out as far as having been able to do enough hiring of custody deputies.
That's correct, Madam Chair. By the end of the fiscal year in December, we wholly expect to have all the custody deputies hired, and they may still be in training at the time, but our plans are moving forward 100%, just like we have the last year, and hire as many as we can.
Okay. It's just that, I've heard about this from some other directions, like the school resource officers and other kinds of things, so I'm trying to get a sense for that. Also, you had said between October 11 and October 12 that overall there was kind of an increase of 19% in the jail, mainly because of the AB 109. Now, was that what you were expecting, or is it more, or is it less, or on target?
The AB 109 impact is higher than the anticipated, even with the revision of the statistics the way we do it. It's still over what we expected. So that impact is higher. We weren't really expecting that many. But the actual number of AB 109 inmates in the jail, you can separate that out from the actual of AB 109, the impact, because we're moving forward and trying to get more out alternative sentencing, alternatives to incarceration. So really, it's a two-pronged answer to your question. The first one is we're experiencing a little bit more than we expected based on the projections.
What had you expected from the projections?
We expected 127 inmates at any one time, and like I said, the snapshot we had on October 1st was 155, just as a snapshot of a day. So that impact is more than we expected. That's in the overall jail system with the way the forecasts were. That included actually inside the walls and outside the walls and alternative sentencing. Our focus right now is trying to get people more on alternative sentencing and GPS to reduce those numbers inside the wall.
Okay. And when you talked about a leveling trend, you're not anticipating then that this percentage increase is going to be getting worse because of these other efforts that you're doing?
Madam Chair, that's correct. The leveling trend we saw during the second quarter of last year for April, May, and June, the AB 109 impact started to level off. The leveling trend, as you can tell by the reports we gave you for this quarter, are virtually even. So I expect that leveling trend to have hit a maximum and to continue, and if we do our job correctly, it may even come down a little bit.
Okay. And then my last question for right now is, I know that we're just talking about the AB 109 issue, but since we're also trying to look at what's happening in custody operations in the jail holistically, during the same time, have we seen an overall increase in non-AB 109 inmates in the jail, so that the whole population is coming up in other ways?
In general, I don't believe we have seen an overall increase. Our actual bookings are up 18% this year over last year, and if you look at the overall impact of the AB 109, that's probably about equal to a lot of the impact. So I wouldn't think we are statistically higher than last year in terms of non-AB 109 inmates. The main impact is AB 109.
Okay, thank you very much. Supervisor Carbajal?
Thank you. First of all, congratulations on another good report and good outcomes. But to better track those outcomes, I want to suggest that if we could, I know we have certain assumptions of what we thought or assumed or hoped. It would be great if we could get something that says, this is what we thought, this is where we're at. It just sort of a fact sheet at a glance. It's a user-friendly fact sheet at a glance. That also allows us to see the challenges that we're having. I think it becomes somewhat of an executive summary of what we're doing or not doing, and it would be, I think, helpful not only to us but the public. So I want to encourage you to do that if you can.
Thank you, Chief Taylor. I don't know if you want to comment on that, but I know that I think you have more of your presentation as well.
Yes, we certainly. Chair Farr, Supervisor Carbajal, we can certainly do that. $1.1 million, or 11.3% of the fiscal year budget, was expended at the end of the first quarter. Hiring challenges continued during the first quarter of the fiscal year and has impacted spending. But based on Chief Deputy Patterson's presentation, there should be an increase in jail, detention alternatives, and collaborative efforts by the end of the next quarter. So we should see some increased expenditures there. In addition, there are claims from contractors and partner agencies that are pending in the collaborative efforts, treatment, housing categories, which will also have an impact. And lastly, contracts are in place, the needs of offenders are being assessed, and referrals are being made. However, we are seeing that the actual experience that we're seeing is resulting in the use of less offender slots than anticipated, and particularly in housing and in our program attendance in Lompoc. But these are two areas that staff will continue to review and look at and find ways to motivate the offenders in Lompoc to attend the treatment sessions. So it's on our radar, and it's something that we'll continue to monitor. So in closing, while it is still too early to discuss the long-term success of public safety realignment, and that's something that's shared by state, counties, and researchers in the field, we do have some local positive short-term outcomes and trends that we're seeing that we'll continue to monitor and provide to the board. We have our evaluation with the UCSB that we should be seeing some information from them in early spring. We also will continue to take advantage of any opportunities for technical assistance or participation in research projects. And in fact, we've been invited by both Stanford University and the Public Policy Institute of Corrections to share our data with them. They are looking to incorporate 10 to 12 counties within the state. They're working with the Board of State and Community Corrections so that the data that they're looking at will mesh with what the state is also collecting. So those are two opportunities that we were fortunate enough to have those two educational entities requests that we participate in. And additionally, the sheriff is taking the lead on a technical assistance opportunity that we're working with him to take a look at our jail system and transition for inmates from jail to the community. So that's another opportunity that we have as well in the near future. As the chair of the CCP, I wanted to just take a moment after our 1-year anniversary, October 1. Certainly, we can all take a deep sigh of relief. But I wanted to just, as a chair, just say how thankful I am to the CCP. They're a dedicated group of individuals who certainly has made this first year of realignment bearable. It's been nonstop and grueling for a lot of our staff who are doing the work in the field. I want to recognize that the CCP saw the need and the benefit of research where the state didn't require counties to have evaluation. We saw the benefit in that and allocated funds for research. The CCP also recognized the need for a multi-prong approach, that it wasn't just top-heavy on incarceration, it wasn't just top-heavy on treatment, but it really was a blended approach with treatment, incarceration, alternative incarceration, and supervision. They're very active in our statewide efforts. Last week we had 8 individuals that went to the 2nd annual AB 109 conference, and I saw that other counties are hamstrung in their efforts, and that was in large part due to the inability for their CCPs to communicate, to collaborate, and to really make decisions and move their plan forward. So I, again, as the chair, I'm very thankful to this county, this board, the board that approved a plan that was the first plan in 2011 from the 58 counties that was in place. We've not only had our initial plan, but we've had our second year plan where we've made modifications as we've seen needs to in the system of service. So I believe that we are forging a path. You've got a group of stakeholders who want to see realignment be successful. We just will continue to look at the state for ongoing funding, because the only way for us to continue with our efforts is if we have the funding to do the job. So I want to thank the board for hearing this first quarter presentation, and I would now like to turn it over to Sheriff Brown for some closing comments. Thank you.
Okay, thank you. Supervisor Wolf, did you have anything that you wanted to say before the sheriff spoke?
No, go ahead.
Okay.
Thank you, Madam Chair, members of the board. Criminal justice realignment remains a huge challenge for us and for every other county in California, but it continues to have some very strong potential to greatly improve the criminal justice system by enhancing the reentry process, thereby revitalizing lives and reducing recidivism and making our community much safer. You heard earlier a comment that was attributed to Dr. Joan Petersilia, who is a professor at Stanford University, probably the preeminent criminologist involved in reentry and an expert in that field, who we are proud to claim as a Santa Barbara County resident, by the way. At this conference that we all attended last week, Dr. Petersilia indicated that there are three key ingredients to recidivism reduction. The first is partnerships, the second is good data, the third is patience. And as far as the first goes, you would be hard-pressed to find a more collaborative criminal justice team anywhere. We all recognize the need for blended strategies as well as the incredible power of synergy. Last week, as you heard, a group of us from the Sheriff's Office, the Probation Department, the DA's Office, the Public Defender's Office, County Counsel's Office, and the courts attended the Criminal Justice Realignment Conference in Sacramento as a team. We have come away from that experience with some new ideas on how we can improve our system, but also confident, as you've heard, that we're doing the right things, that we're headed in the right direction, and that our collective and collaborative efforts are ahead of many others and are on target. Whether through combined efforts to assess risk, to deliver important programs and services both inside and outside of the jail system, communicating with each other at our regular Criminal Justice Coordinating Council meetings, or by taking steps to strengthen and customize discharge plans and post-release supervision and treatment options. We work together in many, many ways to make our system stronger. You heard earlier that the Sheriff's Office and the Probation Department are collaborating on a combined compliance response team project, an effort that we believe will ensure that those who are released early from jail or are on alternatives to incarceration are properly supervised and held accountable. We believe that this will be the first of its kind in California, and that this program holds great promise to become a model practice in our changing post-release environment. The two other components that Dr. Celia mentioned are also coming along well here in Santa Barbara County. We are capturing good data, and we're working, as you've heard, on ways to improve how we harvest that data and assess it. And lastly, we are exercising patience as we put strategies into effect and await the results of our efforts. All of this is being done on the heels of the worst recession in our lifetime. And despite being reduced to bare bones levels, every agency and everyone involved in this effort has really stepped up and made things work, despite significant cuts in staffing and in essential programs and services that have occurred. We still have major funding challenges to deal with at both the state and the local levels, but we are committed to making realignment work in Santa Barbara County, and we thank you for the support that you continue to provide to us in that endeavor. And my staff and the staff of the Probation Department are available if you have any other questions.
Thank you so much, Sheriff. Supervisor Gray, then Supervisor Wolf.
Sheriff, on the AB 1009 money, one of the discussions that seemed to go on and on and on was about program space as opposed to bed space. So now there's this $500 million for capital improvement in program space, which is kind of a new concept for the construction of jails. Does that fit in any way with what we're doing at our jail program level, and how does it fit?
Well, funny you should mention that, because as it turns out, we were very desirous of learning whether or not our award of an AB 900 Phase 2 grant would preclude us from applying for any of this funding stream, and I'm happy to say that it does not. And we are currently looking at what our additional needs are, and have plans to look at applying for an additional grant under the terms of this program. It's very similar in terms of its match requirements, a 10% match, but it does allow us to do refurbishing of existing facilities, for example, or adding program space, as you indicated. And I think there are a lot of things that are going to occur. Remember, we're building a new jail now, but we still have an old jail that's quite antiquated and parts of which are in great need of refurbishment or remodeling to a more modern design and a more effective means to allow us to provide the types of programming that is essential to the success of the reentry process.
As I was listening to the conversation of this commission, it became very apparent to me that the interest was primarily, not totally, but primarily on program space, because there had been a real vacuum as far as the ability to build program space. So I know we'll do a great job in applying for some of those
Yes,
dollars.
we are definitely looking at it, and we'll be working towards that.
And it appears as if there's already been, of the 500 million, it appears that 100 million has already been committed to the smaller counties of which we don't qualify. So there's the 400 million left, but seems to be some real enthusiasm. Sheriff Bach is on the commission also, in making sure that the middle-sized, smaller, because in a way I heard the larger counties say, you know, that's not enough to really do much good for us. So it appears to me like that Santa Barbara County would have a great opportunity.
It may well be a great opportunity because the maximum that can be applied for under this for a medium-sized county is $30 million, which wouldn't be enough for a county that wanted to build a new jail, for example, and it might be that there are fewer people applying for the funding, and we might be able to be in an advantageous position. I believe it's $167 million that's available for the medium-sized counties. So we'll remain.
I don't think that was set in concrete yet. It was just kind of discussed, but that's possible. So, and they could partner. And there was also going to be emphasis on partnering. I don't see that in our future. I mean, we seem to have the jail ready to go, and so it's just program space that I want to be sure and urge us to really be looking at, because that's so new.
It is definitely something for us to look at, and one of the things that we're looking at is, we're already doing 2 very successful day reporting centers in the North and South counties that are for people coming out of the state prison system who are on parole. But we're looking at ways to expand either them or to put a new type of facility that could either be for people coming out of jail or a blended facility that would cater to both ex-offenders, both types of ex-offenders, because many of the services are very similar that we would be providing to all of them. And that's an example of what this money could be utilized for.
Thank you, Supervisor Gray. Supervisor Wolf?
Thank you, Madam Chair. Chief Taylor, the facility that's at the Santa Barbara Juvenile Hall is a location, I think, that Supervisor Gray is maybe talking about, that maybe we can enhance it or have more of those, because isn't that the place where we have the alternative sentenced folks go for job training? There's mental health services, social services. Is that what we're hearing here, that there is grant money for more of those places?
Chair Farr, Supervisor Wolf, the sheriff may have more information about just the specifics for that, but I do know it's a reentry, and our Report and Resource Center does serve as a reentry as well. So for individuals coming out of jail, we prepare a treatment plan in the jail. They can come out and continue services at the Probation Report and Resource Center. So it would be looking at something like that, where offenders are receiving treatment in the community at one location.
Basically, the answer is yes, but it's adults. It's not, when you said juvenile, it threw me off, but it's used.
I didn't mean juvenile. I meant it's the post-sentence, it's the alternative sentenced part of the 109ers.
Felony offenders who are receiving services there. It's the juvenile campus at our Hollister site in Santa Barbara, but we have our adult offenders there.
Yes, correct. That's where the juvenile came in, because it's the juvenile site serving these offenders. And Sheriff Brown, before you leave, I just want to thank you for your comments. This has been an evolving process. I sit on the committee and have enjoyed the challenges that all of you face, and it's really from the leadership from you, Chief Taylor. We have our DA and public defender here. It's a collaborative team, and you certainly have faced challenges, but I think every time we see these reports, we're seeing something a little bit better. We're moving in a direction that I think is a little bit better. You mentioned bed stays, Chief Taylor, and I think last time we noted that was a challenge for us, and things are getting a little bit better. But it will take patience and perseverance, and you guys are a great team, and I just want to thank you all for everything that you're doing to make this
Thank you very much for those
work.
Thank you, Supervisor Wolf. Supervisor Carbajal?
Thank you. I too want to echo congratulations to all of you. But as we're considering 109 and another budget coming, recently I had a very good meeting with Beverly Taylor, and the one thing that stuck in my mind was the numbers. We actually got into the weeds of talking about the numbers of how many probationers, and what really caught my attention was that certainly we made some cuts to the probation department, but whether it was serendipitous or the department was able to restructure in a way to meet the need, but the need also, interestingly enough, went down dramatically. So without objection from my colleagues, at some point in the future, I would really, really appreciate CEO Waller working with all our public safety agencies here, some kind of report that gives us a quick analysis on the 5-year, 10-year trend of incarceration, bookings, probationers. I mean, what has occurred in terms of our public safety with all the numbers? Because oftentimes I know you're going to do your job, and you're also going to come tell us comes June how we need to fund more. And some of the things is that we're just doing it differently. 109 has forced us to do things differently, and I think having a lot more success. But I really would like to understand the data, the numbers of how things are going in terms of the impact, the need, and how we're matching our resources to those. So anyways, if that's something that would be very helpful to me, that would, I think, amplify what we're doing with AB 109, but more importantly, also set us up for our continued discussions on budget in months to come. So I want to encourage that we get a report in the future, a public safety report that focuses on all the arrest data and all the numbers in probation, district attorney. I mean, now we have a diversion program that's going to really focus on, if I remember correctly, 2,000 to 2,500. So I know that everybody's being innovative and creative on trying to do things more efficient. The question is, how are we able to translate those efficiencies into continued growth in the areas we do need them in terms of our public safety department? So it would really be helpful to me to see that data in the future.
Thank you, Supervisor Carbajal. And I just wanted to say that as part of future reports, I would also like to know what kind of trends you're seeing with any of this population dropping into homelessness, because in looking at the financial status for the first quarter, it's sad to me to see so much money there for mental health and alcohol and other drugs, housing, sober living, and so little of it expended. And I think that goes to your comment, Chief Taylor, that there are some issues or problems with perhaps getting people to access the services in the way that we're hoping that they will. And I know that this was an issue that came up at the beginning as far as where people were going to be housed when they came back, and a lot of them thought they were going to be living with family members, and whether that is actually transpiring or not, or whether for other issues, they are not living where we thought they would. I think that we should track that as well. So, because as we know, eventually they're going to end up back at the jail for other reasons if we can't keep them housed and get them back into the programs that we know that they need. So, thank you, Sheriff. I think we have one request to speak from the public.
Madam Chair, we have a request to speak from Andy Caldwell in Santa Maria.
Mr. Caldwell, thank you for waiting.
Thank you, Madam Chair. Members of the board, I'm Andy Caldwell representing CoLab. We have full confidence in the staff that's running these programs. We think we have exemplary people, both in the Sheriff's Department and the Probation Department. However, it was unfortunate that the public didn't get the report. What's on the web was woefully inadequate. It was a cover letter and a couple of charts that with no narrative whatsoever. There's not a lot of people that can come during the day. There's not even a lot of people that can watch during the day, but some people might want to read these reports and they weren't available. And, it also is not helpful to have, as I think Supervisor Carbajal alluded to, just a full-on narrative with no pictorial analysis or no graph. The public, as you know, we supported the creation of the North County Jail because of the overcrowding in the South. And, previously we've all heard the reports that they were barely booking anything less than a felony at the jail. Well, we'd like to know what's happened since AB 109. There's a lot of talk about releasing people on their own recognizance. How many of those people have committed crimes while out on their own recognizance that if it weren't for AB 109, they may have been in jail? That's just kind of a basic little question that the public would like to know. A lot of people are wondering what happens if Prop 30 fails. Is this situation going to get worse? The bottom line is we had an overcrowded jail before. We now have the state dumping prisoners into the county. Are we supposed to walk away and say all is well? Or do we incarcerate too many people? Is there enough people out there that if they just get threatened with jail will mind their P's and Q's? What is the recidivism rate of the people that were not through AB 109 and the ones that were just here on their own? How many people were a victim of a crime because somebody wasn't in jail? Those are the kinds of questions we'd like to have answered. And again, we hope in the future that for all departmental matters, every single piece of information that the board gets will be posted online days ahead so that we can intelligently partner with you to review this and comment accordingly. Today, we had to fly blind into this hearing because the material was not available, and that in this day and age is inexcusable. Thank you.
Thank you, Mr. Caldwell. And that's our only public speaker on this item, so we'll bring it back to the board for any final questions or comments on this. All right, this is a receive and file. Motion to approve by Supervisor Carbajal, second by Supervisor Wolf. All those in favor say aye. Aye. Opposed? Motion carries. Thank you so much, everybody, all the members of the team that are here. Really appreciate that.